In the last voice thread, I gave you something of an overview and preview of the kinds of free speech issues that we were going to touch on. And I also introduced a few historic cases. In this voice thread, I'm going to talk first generally about which categories of speech do not receive First Amendment protection. And then I'm going to delve into the first category that we're going to look at in detail in this class, and that is incitement to unlawful action. In the last voice thread, I gave you a few examples of things from the news that involved free speech issues. And I asked you, are they First Amendment issues? Most of you correctly identified that the issue with James Damore, the issue with Milo Yiannopoulos, are ultimately not First Amendment issues because they do not involve government action, right? So just as a reminder, for something to be a violation of your First Amendment rights to free speech, the action that's interfering with your rights has to be taken by a government actor. As we saw in the last module, as the Bill of Rights has been gradually applied not only to the federal government, but has been incorporated through the 14th Amendment to apply to the states, we can have a broad range of people who are government actors, right? So they might be school teachers at public schools. They might be, again, like elected officials, but generally anybody who works for any level of the state is a government actor for First Amendment purposes. In many of the cases that we're going to look at here, the government actors are law enforcement. And this is law enforcement that steps in often and interrupts someone's attempt to address an audience. So here we are again with the language of the First Amendment. So Congress shall make no law abridging the freedom of speech. Obviously, this isn't no law. So in the next slide, I'm going to give you a brief overview of the types of speech that are actually not protected by the First Amendment. What does that mean, though, if something isn't protected by the First Amendment? It doesn't mean that those things are necessarily illegal. Right, so there's a difference between illegal and unconstitutional. For something to be illegal, it has to be forbidden or punishable according to a criminal law, right? And so the vast majority of the criminal laws in the United States exist at the state level, right? We have relatively few federal criminal laws. So there has to be a law that criminalizes action, but there's a difference between illegal and unconstitutional also, right? So the term illegal simply means that there is some sort of state or federal or municipal law forbidding or punishing the action, but constitutionality applies more to the laws, right? So we're going to look at a lot of laws and policies that are made by legislative bodies, and the question will be whether or not they violate the bounds that are laid down by the US Constitution. Picking up from that distinction that I just mentioned between illegal and unconstitutional, I'm just going to give you kind of a preview of what you're going to see in these cases, right? So often what you'll see is someone engaging in some kind of activity. In the historical cases, it's very often political activity. Now, as you'll gather, as you read the cases moving from the 19th century into the 20th, in the United States, political speech is treated as being particularly relevant to the purposes of the First Amendment. So the things that you're going to see in these historical cases would never obviously pass constitutional muster today. But what you're going to see are people engaging in various types of expressive activity. It might be handing out printed handbills. It might be, like publishing announcements. Or it might be just being out on the street talking to people. In each of these cases, the person engages in some sort of speech that is found to be violating some sort of local or state law, and then they are charged, right? So in each of these cases, you should be asking yourself, what have they actually been charged with doing, right? So no case ever gets to the Supreme Court just because there's a sort of general violation of the First Amendment. There has to be some sort of particular facts that are relevant. So what you'll see here are people being charged with particular offenses. Often, then, what we will see is the court asking two questions, right? So number one, is the problem with this particular government action, right? So this is a law or policy. Is it that the law is facially unconstitutional, or is it unconstitutional in application? So this is an important distinction, because if the court simply finds that this particular application of an otherwise constitutional law does violate someone's constitutionally protected freedoms, then the law will still be allowed to stand, right? But perhaps the particular ruling in this case will be sent back to a lower court to be redecided in a way that's more consonant with the Constitution. However, if the law itself or the policy is found to be facially invalid, right? So on its face, that means the language of the thing violates some protection of the Constitution, then one of two things happens. Either the law itself is struck down, right? So it's removed from the books, it is found to not be a valid law, or the law is sent back to whatever legislature created it, and they can amend it in such a way that it will then be in line with constitutional values. So we're going to look at a couple of laws in this section, specifically the 1918 Sedition Act, and also we're going to look at a couple of criminal syndicalism acts that are themselves on their faces found ultimately to be unconstitutional. So I just want to clarify that before we get into those cases. All right, so as I said, yes, you have a right to free speech, but it's not an unlimited right to free speech. In the United States, we have some of the most robust free speech protections in the world, but they aren't actually limitless. So there are a limited number of types of expression that actually are not protected by the First Amendment. What does that mean? Well, if you are engaging in, say, publishing obscenity, or if you are engaging in true threats, if you are then charged with breaking some sort of law, say making terroristic threats or harassment, right? So if you are then charged with breaking some sort of state, federal, municipal law, you can't successfully mount a First Amendment defense. So in the cases that we're going to look at, especially in this section, you're going to see people doing things that they admit are breaking laws, right? So for instance, we're going to look at the expressive conduct cases, US v. O'Brien and Texas versus Johnson. In both of those cases, we have people who are doing things that they know are illegal. In US versus O'Brien, O'Brien burns his draft card. In Texas versus Johnson, Johnson burns an American flag. But then when they are charged with having engaged in criminal conduct, they push back and say, like, yeah, I broke this law, but the law is invalid, right? So I'm going to mount a First Amendment defense and say that I did break this law, I did burn my draft card, but you shouldn't punish me for this because this is actually an activity that is protected by my First Amendment freedoms. So that is what we're going to see kind of fought out in the incitement cases. But here is a more or less complete overview of the kinds of expression that is not protected by the First Amendment. So if you are charged with a crime that ends up falling into one of these categories, you wouldn't be able to successfully defend yourself by saying, well, yes, I did it, but this is covered by my First Amendment freedoms. So the first category that we are going to look at in depth is incitement to illegal action. And the reason that we're going to look at this first, because this isn't really the category that you see in the news most often. It's probably not the one that you as citizens are most likely to potentially engage with, but it's really important for the history of free speech. So many landmark free speech cases deal with kinds of expression that threaten the government, right? And so this might be criticism of the government, it might be calling outright for its overthrow, or it might be urging people not to cooperate with a war effort. So these are the kinds of confrontations between individual liberties and government policies that are kind of at the heart of the First Amendment. But there are other important categories. So the ones on the slide that are in bold are the topics that we're going to look at in more detail in this module. So the first of these is obscenity, right? And I'll say more about this when we get to obscenity, but this is today a very limited category, right? So you can probably think of some things that are pretty gross or offensive or indecent, but expression can be all of those things without quite reaching the standard of obscenity, which is defined in a case called Miller versus California. There's a test for it. Suffice it to say, there's not a lot of stuff now that actually meets the obscenity standard. 2, fighting words. Fighting words is kind of a cousin of incitement to imminent lawless action. And I say that because both of these categories of exception are concerned with breaches of the peace. By breaches of the peace, I mean essentially the outbreak of violence. So incitement has a different kind of like directionality to it. When we look at incitement to illegal action, the state's interest is in keeping order, but the threat that the speech poses isn't from the speaker, him or herself. The threat is from the speaker's audience. So what happens in a case of incitement is some speaker gets up there, they talk to an audience that is likely to engage in that moment in some kind of lawless action, some sort of mob action, right? This is very often the case. And so the state asserts in these cases that it has a right to step in and punish or end that speech, the justification being that the state has a compelling interest in keeping the peace. Now, fighting words is a bit different. Fighting words is also concerned with keeping the peace, but the concern there is not that the audience will go out and commit violent acts or unlawful acts against a third party. Rather, the concern with fighting words is that the speaker is talking in such a provocative manner that a reasonable person would expect this to cause the audience to attack the speaker, right? So the speaker is actually endangering themselves in fighting words cases. However, the concern isn't necessarily phrased, right? So the state's justification for stepping in and preventing or punishing this type of expression isn't necessarily for the speaker's safety per se, right? This isn't like a paternalistic concern, but rather having breaches of the peace, right? Having lawlessness is itself a harm to the state and to the public that the state has a right to step in and prevent. All right, so this brings us to defamation. So we'll talk about defamation later. We're only going to spend a little bit of time on freedom of the press just because we only have so much time in the class. But we will look at libel specifically in relation to freedom of the press. So defamation is a category that we get from the common law, right? So this means this is some like prohibitable conduct that has been around for a long time and predates the Constitution. So often we will see defamation / libel slander coming up in tort cases. What's a tort? Well, what we're looking at in this case, constitutional law, belongs to the realm of law that's called public law, but there are other kinds of law, right? So we're going to talk a lot about criminal laws in this class because often the people who are defending their constitutional rights have been charged with criminal laws. The parties involved in a criminal law case are the state and some private individual, right? The argument being that the private individual has done a wrong to the state by breaking the law. That's the nature of a criminal case. You don't go, so if you commit a crime, you don't go to court against another private individual, right? The victim of a crime doesn't go to court against the perpetrator. Rather, the perpetrator goes against the state. Now, tort law is part of civil law. Civil law deals with individuals, right? So sometimes those individuals might be companies or corporations, but just as often, they're just two private citizens, right? So, if your neighbor knocks down your fence and does some kind of damage and you want to take them to court and sue them to pay for those damages, this would be the kind of thing that falls under civil law or torts, right? So torts deal with wrongs. So defamation, which is a broad term for a number of more specific things, but libel and slander have traditionally fallen under tort law. The First Amendment limits liability for torts involving expression. This means that it limits the kinds of wrongful acts that can actually be punished under civil law, or for which damages can be recovered under civil law. So what are expression-related torts? Well, libel, slander, right? There are tests for that. But there's another one that we're going to discuss in relation to Snyder versus Phelps, and also Hustler Magazine versus Falwell, that is intentional infliction of emotional distress, right? So this is harm that is intentionally inflicted through words. Now, that said, this isn't a criminal charge, and we'll talk when we get to that more about the relationship between this tort, intentional infliction of emotional distress, and hate speech. But we'll get to that later because that's quite complicated. But there's another tort called public disclosure of private facts, right? So this is, again, a legal wrong that involves expression. So there are certain legal wrongs that involve expression that are allowed, right? Or that you might get by with, basically if you mount a First Amendment defense. And there are others that are less limited by First Amendment defenses. And we'll talk about those as we go. Child pornography is another area of exception. So we'll talk about this also in a bit more detail. But ultimately, this is an area of exception that the court carved out because it found that this form of expression was inherently harmful to children, right? And not because it's sort of a bad influence, not because it does some sort of moral harm to the people who consume it, but because the making of this type of pornography inherently involves harm to the children who are involved in the making of it. So for that reason, child pornography, not protected by the First Amendment. Then there's a category of there are various crimes that inherently involve speech, right? So these are crimes that cannot sort of go forward without expression. These include perjury, right? So perjury is an utterance that is in and of itself criminal. If you lie in court, yes, you're engaging in expression, but no, you can't mount, a freedom of speech defense for that because it is a crime that itself involves expression. The same is true of blackmail, right? So this is demanding money or engaging in extortion with the threat that you will disclose information, right? And that disclosure of information is expression, but it's not expression that's protected by the First Amendment. Solicitation to commit crimes is another related category. We're not going to go into this too much in this class again because we just have kind of time restraints, but there are some interesting cases involved with this, right? So there's one in particular about, like a hitman manual. And if that's published, well, can that be prohibited? Spoiler alert, no, it can't. However, solicitations to commit crimes, right? So the emails, maybe, like that neighbor who backed over your fence, and just like trashed your garden, you're really angry. You decide to respond to this by going on Craigslist, right? So you go on Craigslist and you look for a reasonably priced assassin to go take out your neighbor. Well, the emails that you exchange with that assassin, via Craigslist are not necessarily protected expression. Same thing if you're texting with that Craigslist assassin, laying down the terms of your contract. Those are, under the criminal law, steps towards committing an unlawful act. So these are, again, utterances that maybe themselves don't constitute a crime in the way that perjury or blackmail does, but they are essential steps in the commission of a crime. And so they also are not treated as protected expression. So sorry, I don't recommend trying to mount a First Amendment defense when you go out and try to hire a killer off Craigslist. Also, don't hire a killer off Craigslist. Finally, treason, right? So treason is another form of communication. It may or may not involve communication because treason can also involve actions, right? So for instance, giving material support to enemies of the country can be treason, but also giving away information, right? So if somebody, say, sells vital intelligence information or security information about the country to a foreign interest, then yes, they're engaging in expression because they are, conveying information, but that expression also is not protected by the First Amendment. Similarly, plagiarism, right? Plagiarism is expression, but it has this potentially prosecutable element to it that is, violating intellectual property rights. All right. Finally, this brings us to true threats, right? So there's a fine line between sort of like hyperbolic utterances that somebody might engage in when they're angry or as part of a protest, or as part of, maybe some other political demonstration, and actually making a threat, right? So you can't go around threatening to harm other citizens. That is not a protected kind of expression. So there is, in fact, a test for this, and we'll touch on this when we get sort of to the end of the one of the what would be a hate speech case if we had a category for hate speech, but you'll note we don't. RAV versus St. Paul. So we do have a test for assessing what is a true threat as a sort of like basic preview. There has to be some sort of like specificity to the action that the person is saying they're going to engage in, and there has to be a clear target. So true threats also, finally, not protected by the First Amendment. So this is not, just to be clear, a completely comprehensive list of kinds of expression that are not covered by the First Amendment. But generally speaking, anything that is not protected speech is going to fall into one of these categories. Having gotten all of that out of the way, we're now going to turn to the first category of exception, which is incitement to illegal action. So again, we're going to kind of like look back into the past. I mentioned in the last voice thread the Sedition Act the Sedition Act of 1798, right? So that's speech criticizing the government that was criminalized, right? And the Supreme Court never overturned that. It was actually never challenged on First Amendment grounds. But this really becomes a hot issue later, right? So during World War I, we're going to see a lot of these key cases arise. And then finally, we will see this resolved with Brandenburg versus Ohio in the late 60s. So, okay, illegal action, right? Like, is advocacy of illegal action necessarily punishable? Should it be? Do we necessarily want people standing on street corners, criticizing the US government and saying that people should go out and overthrow it? Well, this is one of the questions that we're going to examine here with incitement. So we're going to look at a line of cases that deal largely with people criticizing the war effort and encouraging potential soldiers not to enlist, right, or to resist the draft. So these cases are Schenck versus US, Debs versus US, Masses Publishing Company versus Patton, which I don't believe that your book addresses. This is actually a federal court case, which might be why your book doesn't go into it, but it ends up being actually very important for the evolution of free speech jurisprudence. Then finally, Abrams versus US. So this is a key case because we see Justice Oliver Wendell Holmes change his mind, right? So he moves from one standard to a much more limited standard in Abrams. And this is sort of one of the great questions in the history of constitutional law. Why did Holmes change his mind? Well, it ends up being really important in terms of changing the direction of the court on advocacy of illegal action. All right, so we're going to see a couple of different tests arise also. So I just want to, again, kind of remind you that what we're going to look at here are historic tests, right? So this is kind of like Sherbert versus Werner, right? So remember going back to the freedom of religion cases, first there was the Sherbert test, but then along came Employment Division versus Smith, and Sherbert was no longer good law, right? So the most recent test always takes precedence. What we're going to look at here are historic tests. So we're going to look at first, the bad tendency test. This is a little bit confusing because the bad tendency test was a common law inheritance from Britain, right? And so when the US was founded, this was kind of the default. So speech that had a bad tendency, right, to cause disorder, to encourage disloyalty, that could be punished under the bad tendency test. Well, as we'll see, the bad tendency test is then replaced by the clear and present danger test, which is much narrower. Right? So there's an immediacy piece that's added with the clear and present danger test that was missing from the bad tendency test. However, then the court turns around and moves back to the bad tendency test from the clear and present danger test. All right, so we're going to see this kind of going back and forth in a number of ways. And then the question is kind of going to be left dangling after the 1920s until the next major case that we're going to discuss, which is Brandenburg versus Ohio. And then we'll see the current test articulated, which is much, much more narrow than either the bad tendency test or the clear and present danger test. This might all seem kind of quaint to read now, because the kinds of criticism that many of these people are engaged in today, like, wouldn't even sort of raise an eyebrow. But I want to give you a little bit of historical background, just to sort of like get you into the mindset that the court and the American people were in at the time of the cases we're about to look at. So today, okay, you hear the term anarchism. What do you think? Right? Like, oh, I saw a scary post by Antifa. Okay, well, that's something that lives on the internet. That's not really real. Or, you know, maybe when you were a teenager, you went out and painted an A in a circle, right, with the lines of the A sticking out of the circle on something. Or maybe, you know, like you have an annoying teenage cousin who just discovered anarchism and wants to talk about it. The point of all this being that in the contemporary US, anarchism isn't really treated as a political movement that has any kind of teeth, right? It isn't really treated even as an ideology to be engaged with. This has not always been the case, right? So today, the American left is, you know, disaffected Bernie bros, right? Or maybe Twitter tankies. But for the most part, the left in the United States is pretty moderate, especially compared to Europe. And frankly, especially compared to the United States, or the United States' own past. So anarchism was a growing... apologies for the break in this. I was signed out of VoiceThread mid-sentence. Apparently I get too excited talking about anarchism and go over my time limit. But as I was saying, you know, in the United States in the 19th century and also in Europe, anarchism was a growing political movement. So I'm not going to go into great detail here on anarchism, right? So I'm teaching a whole other class on anarchism. But what I do want to make clear was that this was kind of like the political threat that was very much lurking in the background of American life in the late 19th century and the early 20th, right? So this is the background that all these cases take place against. So there are, to be clear, many schools of anarchism, right? So many of them are pacifistic. There's a particular French strain of individualist anarchism that, especially in the 19th and early 20th centuries, did promote violence, right? So they referred to it as, and I quote, propaganda of the deed, right? And so this was trying to motivate, you know, the masses to rise up by doing things like assassinating political figures or, you know, blowing up symbols of the nation. So essentially, it's like proto-terrorism. So this went on in Europe, especially for about 20 or so years, and it also touched the United States. So a lot of Americans have kind of forgotten this now, but President McKinley was assassinated, right? And he wasn't just assassinated, he was assassinated by an alleged anarchist, right? So there is some question about how ideologically motivated this was, because, you know, the person who did this, Leon, I'm probably slaughtering this name, but Jogoj, was reported by other anarchists who had met him to be sort of a weird loner. He kind of tried to network with other anarchists. They thought he was a spy. So how ideologically motivated he actually was is questionable. But regardless, the story that Americans heard was that an anarchist had assassinated the president, right? And so people were afraid. The left in the United States in the late 19th and early 20th centuries had just like much bigger teeth, and had some power, right? And there was this violent aspect to it that scared people. I'm going to conclude this voice thread here, and then pick up with the details of the cases in the next voice thread, just for the sake of keeping the voice threads to be sort of like manageable chunks. So I would urge you to take a break, get a coffee, some cookies, your pet, whatever, before you go to the next voice thread. So the next one is going to go in detail into the like landmark cases. So Schenck, Abrams, Masses Publishing Company, Gitlow, etc.